May it please the court, my name is Tatiana Ostapov. I'm Assistant Public Defender, and I'm appearing today on behalf of Keith Peters, the appellant. This is a pretty straightforward case. It's credit for time served is the issue, and the facts are basically uncontroverted. Mr. Peters was a juvenile, 16 years old at the time that he committed these offenses, originally sentenced to life plus 240 years, which is a lot. Since then, Graham has come out.
But these weren't death cases that he was sentenced on? Right, okay.
No, they're non-homicide cases, so it's under Graham. There was a resentencing set then in 2011, which took under consideration both a score sheet error, a sentencing guideline scoring error, and also Graham was a factor. At that 2011 sentencing hearing, he was resentenced to concurrent terms on all of his cases, every single one. And the basically 99 years, excuse me, was the total sentence. The robberies all got 99-year sentences. And the reason that they did that was because the state believed at that time, probably correctly, that 99 years was a legal sentence under Graham, at least as far as this court at that time had already issued Guzman, which held that term of year sentences, even if they're really, really big, still are not the same as life sentences. Now that, in the meantime, has been overruled by the Florida Supreme Court, but we're not here to discuss that part of the case today. In any event, there was a reason for them to make all the sentences concurrent. That's what they did. And it was concurrent nunc pro tunc to the original sentencing date, which is what we ordinarily do.
Well, let me ask you that. I mean, wouldn't that, let's say he didn't say anything about nunc pro tunc. I mean, wouldn't that be the way it would have to have been on a resentencing? Is it ever not? Does it ever, if you have to resentence because the sentence is illegal, isn't it always measured by the date of the original sentence?
I think it is. I've never seen one where, I mean, I don't see how you could actually come back and say, well, he serves the illegal sentence, the consecutive time, for 6 months, but then now that we've resentenced him, now it's going to go concurrent. That doesn't make any sense. So yes, to me, and it seems like every time you resentence where there's a clearly acknowledged error in the original sentence, that...
Now, if it was consecutive, that'd be a different story, correct? I mean, if a sentence
Yes.
consecutive,
Yes.
then the time credits wouldn't accrue to the second sentence until the first sentence has been completed.
Yes,
So
that's
the key
correct.
difference, it seems to me, is the fact that it was all made concurrent.
That's correct.
Had it been consecutive, maybe it'd be a different posture.
That's right. And it was a different posture when it was consecutive, but now it's concurrent. Now, it was made concurrent in 2011, and it became, all those sentences ran, first of all, there are 99-year sentences, not life sentences. But they all ran from the date of the original sentencing, because that is how it works.
Now, I know that the argument's going to be that this is a mistake and that the intent was to make sure that it was a certain length of sentence. How do you address the question of whether or not when we sent it back the first time for resentencing, did we touch that issue? Did we, in other words, of making it a non-pro-tunc from the beginning, or is that something that he gratuitously did? Was that a mistake, therefore, that would not be covered under a double jeopardy issue?
It wasn't a mistake. It was intentionally done. It was intentionally done, first of all, so that the total sentence would be 99 years. So that's why they were all made concurrent. And secondly, because it was the expressed intent of the judge, the sentencing judge, that Mr. Peters not lose any of his gain time, which he might have done. So that there was an intent, there was a purpose to doing it concurrent. It wasn't a mistake. It wasn't something slipped the judge's mind. It wasn't, that he misspoke. He said it like 6 times, more than that, that they were concurrent.
Yeah,
so
that's theoretically, he probably thought it was a 99-year, and this is giving him 20-plus years of credit. Had he known it was 40, he may or may not have. But how would you answer that question? Is it too bad for him? He should have, the fact that it was 40 as opposed to 99, and he incorrectly thought that 99 was
He intended to make them concurrent at the time of the sentence. If something comes up later to change his mind, he can't just go back and alter that. That would, in fact, be a double jeopardy violation. So, I mean, I don't think that, and I don't see that it's really terrifically, it doesn't get us very far to try to cipher out what the judge did, especially where it's expressed in the record, or what the judge's intent was, where it's expressly in the record that he clearly intended to impose those concurrent sentences, and he understood that they would run from the date of the original sentencing. So there wasn't any kind of a legal mistake or, overlooking or misstatement which would be allowable as an excuse to try to change something later on. So as to the non-protunct, I think case law is pretty clear. Certainly when you say it, I think probably even if you don't, but certainly when you say non-protunct, that has a specific legal meaning, and it means it goes back now as then. It goes back and changes from the beginning what your sentencing amendment is. And those non-protunct, that language has been used in many, many cases where concurrent sentences are then thereafter imposed. State v. Rabideau is, I think, a case that demonstrates what happens once you do serve the concurrent time, which Mr. Peters did by operation of law from the date of the original sentencing up until the final resentencing in 2014. Once you serve that time, you get credit for it. Once a defendant actually serves the time, credit naturally and legally follows. That's from State v. Rabideau, right at the end. It concludes that. So once you serve the concurrent sentence, or once you serve that time, that can't be taken away from you later on. And Rabideau is a good illustration of that, because in that case, the defendant was originally sentenced to concurrent sentences. On resentencing, he got consecutive sentences. The judge thought, well, now they're consecutive, so he only gets credit for time served on one of them, as would happen in a consecutive sentencing case, but not on the other sentences. And the Supreme Court says no. When those sentences were concurrent, when he was serving them concurrently, he was serving each one of them. And when he served them, that right to that credit vested, and it couldn't be taken away even if the sentences were later changed to consecutive sentences. And that's basically the situation we have here. At the 2014 sentencing, it really was a unique situation, because the defense attorney agreed, the prosecutor agreed, the Department of Corrections agreed that Mr. Peters was entitled to the credit for that time that he had served while the sentences were concurrent, all the way back to the original sentencing. The person who didn't agree was the judge. And despite all legal authority, to the contrary, he persisted in trying to make this sentence, trying to ex post facto fix this concurrent sentences so that they only ran from the date, the 2011 date, which is just, I mean, that's just hard legally to grasp how that could possibly work. There's no question that the court had power, the jurisdiction, to resentence Mr. Peters both in 2011 and in 2014. So the judge was talking about that his prior sentencing order was a nullity because it had to be changed. It wasn't a nullity. A nullity is when you don't have jurisdiction to act at all. So there was nothing null and void about that prior judgment. It just needed to be corrected, which it was. If the court has no further questions, we'd request that this case be reversed with directions in accordance. Thank you.
Good morning. May it please the court, Matthew Oxrider on behalf of the state of Florida. As Judge Levine, you pointed out, the issue really, the threshold issue in this case is whether this court's 2013 opinion in Peters reversed the sentence as a whole, or whether it touched just the 6 first-degree felonies punishable by life. We would submit that based on the language in the first paragraph where this court said, we reverse thus sentence, that the sentence was completely wiped out, therefore it was nullified, as the judge used. And this was returned to a de novo resentencing hearing where the trial court was able to start from the beginning, basically, with sentencing and jail credit.
Yeah, but so I mean, didn't that case, our case in 2013 was a pretty complicated case. In other words, it dealt with a lot of issues. And in saying that the sentence was limited to 40 years, right? That's really what we
Right.
said. There was a choice. There were two choices, and so we go 40 years. So in going back, I mean, wouldn't that sentence have to be measured from the early 1990s when the guy started to serve? I mean, how could a sentence be illegal and require resentencing, and the guy not get credit for all the time, whatever the law was at the time he served, as if he had gotten that legal sentence originally? That's essentially what that case, what happens on resentencing.
That's correct, but, well, first I would, okay, that is correct, but what I would say is that if that nunc pro tunc language, the only reason Mr. Peters was entitled to additional credit on this case on any other case but the first one where he had the life sentence where everything was then consecutive, as Ms. Ostapov said, was by virtue of that nunc pro tunc language. And as the trial court pointed out, that order's a nullity. Now, none of the parties were operating under that, and I would submit that the DOC's memo, which is in the second supplemental record, particularly on page 10, it doesn't even seem to indicate that they understood that this was a complete resentencing. So the parties and the DOC appeared to be under the belief that they were just coming back for those six cases, excuse me. If that was the court's intent, then I would absolutely concede that the trial court lacked authority to go beyond the mandate. And obviously, Judge McCann resentenced on second and third degree, like grand theft counts, attempted armed robbery counts. He had no authority to touch those. We would agree that it would have to go back on that point. But with regard to those six first-degree punishable by life felonies, I would point toward Copson, which talks about the lack of finality.
Copson is a consec case. That's the key difference. I mean,
I do understand that.
yeah, I mean, well, that's.
No, I understand, Judge.
I mean, therein lies the problem. I mean, if I think Judge Warner was right on a consecutive case, but once, if I understand it correctly, the way 2011, when he made it non-pro-tunc and made it concurrent, he did it with 99 years. Then later on, he was, not to his fault, it was 40 years. Well, now he has buyer's regret. Too bad.
Well, I'm not necessarily sure it was buyer's regret. I think he was trying to comport with the law on both sides of the
But didn't
opinion.
he say, I'm going to get you to the defendant? He said, I'm going to get you your credit from the beginning.
Yeah, and I cited all of those passages, especially from the
Sure.
2011 sentence in my brief, where he says, he makes it clear, and I agree with Ms. Ostapov again, that 2011 order is not a mistake. I think Judge McCann pretty clearly knew what he was doing based on those comments that he made at the original 2011 sentencing hearing. It's just now we get to this capped 40-year sentence, as the 2013 opinion made clear that those first-degree punishable by life felonies needed to be. And once they were capped at 40, Judge McCann now gets it on resentencing and is just trying to effectuate his original sentencing intent, which was Judge Walsh's original.
Isn't he he has served part of the sentence since the 2011 from the beginning, right? From
Based
the
on the
beginning of
non-pro-tunc language,
1991,
right.
right? So, and the Rabideau case talks about the fact that once you serve some period of time, I mean,
It says actually served, so I guess it really depends
we
on.
actually served from 2011 to 2013.
And he was granted credit from 2011 to 2014 on all of the felonies. It was just from 2011 to 1995 when he started serving the sentences on this case that he only got it in the 89-2908 case.
Suppose the sentence on remand had, the first time that he was resentenced in 2011, suppose that sentence had been 99 years on each of the robberies consecutive. Wouldn't that sentence have been reversed because, under the state of the case law now,
Oh, absolutely.
Graham and its progeny? So
I mean, the 99-year sentence.
so he
probably.
couldn't have really gone
No, definitely
Consecutive,
not.
right.
He couldn't have gone consecutive based
with
on.
those numbers, right?
Burdine and Henry would have definitely prohibited that, even if they weren't out at the time of the resentencing. I know Judge McCann at the 2014 hearing sort of expressed remorse that Guzman hadn't come out yet when he resentenced him in 2011. Had he known it, he definitely would have stacked those sentences because at that point, like 270-year sentences were being upheld. Obviously, that's not the state of the law anymore, and Burdine and Henry.
The law's really changing this.
No, it's become very clear at this point that, I don't even know if a 99-year sentence would survive.
Okay,
but-
I have one appellate procedure question. On page 7 of your brief, you quote at length what the ASA said in court. And it appears that he agreed, and all the other state actors, as you kind of said, agreed that he was entitled to gain time on the 40-year sentence. I mean, does that just, because it wasn't raised below, I mean, the state is now taking a different position on appeal, does that waive the right to make that claim on appeal, purely as a matter of appellate procedure?
I think on appeal now, just purely as a matter of appellate procedure, we're looking to see if there's anything that can support now what the trial court did. And so if any time the state conceded in the trial court, we essentially waived our right, there would be no reason to even brief cases because it would just be reversed and remanded, basically summarily. So if there's anything really to support the judge's actions, and this court rejects our concessions from time to time as well, so I don't think that that's necessarily binding on me. I realize, and I pointed this out in my brief, this is a very unique case. It's definitely one of the first times I've ever had to deal with a situation where every party agreed. But what I will say is that the state attorney, I think he was deferring to the DOC, not necessarily agreeing with them too. So I think specific to this case, I think what he was saying was he got this recommendation letter from the DOC, and he didn't believe it at first. And quite frankly, Ms. Griffin, who represented Mr. Peters at the resentencing, didn't believe it either because, for whatever reason. But I think he just deferred to maybe what they had to say rather than actually go and look at it himself. And again, it's just our position that the 2013 opinion wiped out that nunc-pro-tunc language, which is the only reason that Mr. Peters was entitled to any credit prior to 2011 on the remaining 5 cases. And as I pointed out in my brief, if this court considers that essentially a distinction without a difference, then I have.
Well, what about what I asked Ms. Ostapov? When a sentence is illegal because it's like under the Graham cases where they go back for resentencing, I mean, don't they go back for resentencing measured from the time the original sentence began? I mean, even if that judge doesn't say nunc-pro-tunc.
I think, and I'll point to the initial brief on page 17 here, and this is what the DOC testified to. There's 2 ways to impose credit on resentencing. The court expressly grants credit for time served on the amended sentencing order, which is exactly what happened here, or the court uses the nunc-pro-tunc language. So in this case, what Judge McCann did was just simply break down the actual time that Mr. Peters served on each of these 6 cases, 95 to 2011 on case number 89-2908, and then 2011 to 2014 on the remainder of them, because this was a resentencing hearing. He basically was starting fresh, and that was basically nullified any of the nunc-pro-tunc effect at that point. And if there are no further questions from the court.
Okay. Mr. Oxrider, thank you very much.
As far as the gain time, I think that what the discussion was below was that the DOC sets gain time. They compute that. And part of their computations are based on the time served. So that based on how many months have already been served, that's how much gain time gets assigned. So that's why the gain time is actually really related to the credit for time served argument that we're making now, because in fact, even though the intent of the judge was that Mr. Peters not lose any gain time, in fact, he has lost gain time because by the reduction of the credit for time served, that necessarily follows.
So what's interesting is, I mean, like Mr. Oxrider did point to that testimony you cite on page 17 of the initial brief, that as to what the DOC guy testified to. But it's interesting that no lawyers or judges ever seem to cite any statutes. I mean, like where this has to come from some place. In other words, but everybody, it's either so boring or so hard that everybody just defers to the DOC on that. So, I mean, I've never seen a statute that really says what's supposed to happen.
I don't know that there is one. I think that is a matter of case law. There's one statute that says when a sentence will be presumed concurrent as opposed to consecutive. I mean, in that situation where the judge doesn't say which it is, there's a statute that governs what the prison how they will interpret that. But I don't think there's any specific statute. There's certainly nunc-pro-tunc is a term of common law, right? That's just that's where that all comes from. The concurrent sentences is also something I think that courts are allowed to allow a defendant to serve his time on multiple sentences at the same time. That's a matter of grace from the courts, and that's been recognized. But I don't know that there's a statute particularly that governs that. I'm not 100% sure on Guzman, but I'm pretty sure that at the time of the 2011 sentencing, that case had already come out because because the reason that they went to 99 years was because that was a term of years that they thought under Guzman would be okay as not quite a life sentence. And so that decision was there. The judge knew about that. But, and unfortunately for him, well, or not, the Supreme Court has backed off of that.
Applying the nunc-pro-tunc analysis, given all of the credit time served here today, if that had originally been imposed, would he still be incarcerated?
I think not. The parties seem to be, the DOC thought not, that he would be entitled to release, immediate release. So, yeah, it's been a long time for him. I think he did want to have his appeal thoroughly considered, but he's been in for a long time since he was entitled to be released. And I can't really say anything.
Okay. Okay.
Thank you.
Thank you.
Thanks, folks.